Chapter 2. The Rule of Law. It seems convenient to retain the expression "the rule of law", especially as it has become perfectly well known to more than one generation of Englishmen. But the expression itself is not free from ambiguity. It is often used, for example, in the sense in which a particular proposition or statement of legal doctrine is described as being a rule of law, but that of course is not the sense in which it is used here. What is meant here by the rule of law is the supremacy or the predominance of law, as distinguished from mere arbitrariness, or from some alternative mode, which is not law, of determining or disposing of the rights of individuals. It is, or at any rate it was until quite recently, a commonplace to say that the rule of law is one of the two leading features which distinguish our constitution. So it has been ever since the 11th century, and if this leading feature or essential characteristic is to be diminished or destroyed, it seems at least desirable that the work of diminution or demolition should be openly and frankly performed, with the British public standing by, fully instructed and deliberately consenting. Nothing could well be more unfortunate than that a change of so fundamental a character should be brought about piecemeal, by subterranean methods, which might escape general observation until the mischief had been carried to completion. Professor Dicey, in his classical work on the Law of the Constitution, enumerates three distinct yet kindred conceptions which are involved in the statement that the English Constitution is characterized by the supremacy, or the rule, of law. The statement means first that in England no man can be punished or can be lawfully made to suffer either in his body or in his goods, except for a distinct breach of law established in the ordinary legal manner before the ordinary courts. It means, secondly, that in this country not only is no man above the law, but every man, whatever his rank or condition may be, is subject to the ordinary law of the land and the jurisdiction of the ordinary courts. And finally, it means that the general principles of our Constitution are mainly the result of judicial decisions determining the rights of private persons in particular cases brought before the courts. There is probably, at this time of day, little need to expound the meaning, or to dwell upon the importance of these essential principles. Englishmen, indeed, are so thoroughly accustomed to them as to take them for granted. They have become a second nature. They are, so to say, part of the bracing air we breathe. They exemplify, as they spring from, that love of justice and respect for it, which have excited witnesses from other countries, like Tocqueville and Voltaire, for example, to tributes so manifestly sincere, a love of justice which in its turn is closely bound up with the unchanging passion for self-government. The underlying contrast, the permanent antithesis, is between the supremacy of the law on the one hand, and on the other hand the arbitrary, which may easily prove to be the capricious exercise of lawless power. Nothing, perhaps, is more profoundly repugnant to the English mind than that authority should be irresponsible or uncontrolled, that it should operate at pleasure or in the dark, that men should live in an atmosphere of uncertainty as to the nature of the rights they enjoy or the penalties to which they are exposed, or that among fellow citizens there should be one code for one class of persons and a different code for others. With us, as Professor Dicey says, every official from the Prime Minister down to a constable or a collector of taxes is under the same responsibility for every act done without legal justification as any other citizen. The reports abound with cases in which officials have been brought before the courts and made, in their personal capacity, liable to punishment, or to the payment of damages, for acts done in their official character but in excess of their lawful authority. A colonial governor, a secretary of state, a military officer, and all subordinates, though carrying out the commands of their official superiors, are as responsible for any act which the law does not authorize as is any private and unofficial person. But the supremacy of law, as we know it, means something more than the exclusion of arbitrary power, and something more also than the equality of all citizens before the ordinary law of the land administered by the ordinary courts. It means that, in this country, unlike some foreign countries, the principles of the Constitution are, in Dicey's phrase, inductions or generalizations based upon decisions pronounced by the courts as to the rights of particular individuals. Under the contrasted system, where the Constitution is written out in declarations or definitions of rights, the rights of the individual may be said to be deductions drawn from the principles of the Constitution. The contrast is vital and is to be traced to profound differences of history, of temperament, and of outlook. This is not the place for any comparison of the respective merits and advantages of the two systems, but it may at least be observed that, under the system which we know, it is far more difficult for constitutional rights to be suspended or taken away. To summarize the matter, it may be said that the rule of law comprehends and denotes the following principles. 1. no one can lawfully be restrained or punished or condemned in damages except for a violation of the law established to the satisfaction of a judge or jury or magistrate in proceedings regularly instituted in one of the ordinary courts of justice. The rights of personal liberty and of freedom of speech, the liberty of the press, and the right of public meeting are all a result of the application of this fundamental principle. 2. Everyone, whatever his position, minister of state or government official, soldier or policeman, is governed by the ordinary law of the land and personally liable for anything done by him contrary to that law, and is subject to the jurisdiction of the ordinary courts of justice, civil and criminal. The plea of act of state is not permissible as a defence to an action in respect of anything done within the realm, or to any action by a British subject. It is confined to proceedings commenced by foreigners in respect of duly authorised acts done by officers or servants of the Crown abroad. The Crown, that is to say the government, cannot itself be proceeded against, either by petition of right or otherwise, for any alleged wrong on the part of its servants. The remedy for any such wrong is against the individual wrongdoer, but in practice the Crown as a general rule pays any damages that may be recovered against its servants for wrongful acts committed in the course of their public employment. 3. No one who is charged with a violation of the law can effectively plead, either in a civil or in a criminal court, that his act was done in obedience to the command of a superior, even the command of the king himself. The maxim, "the king can do no wrong," imports not only that the king cannot be proceeded against for any alleged wrong, but also that he cannot authorise any wrongful act so as to justify the wrongdoer. The right of personal liberty is the right not to be arrested or detained or otherwise subjected to physical restraint, except in accordance with the law. And to speak generally, that is to say, except in the case of persons who are not sui juris, or persons subject to military law, the law recognises an arrest or any sort of physical restraint as justifiable only where the person restrained is suspected of having committed a crime and is arrested in order that he may be brought before the court for trial, or where he has been convicted of a crime and sentenced to imprisonment. The law affords 3 remedies by means of which this right of personal liberty may be vindicated. 1. By the writ of habeas corpus. 2. By an action of damages for false imprisonment. And 3. By a prosecution of the person imposing the illegal restraint, that is, a prosecution for assault. The writ of habeas corpus is a very ancient common law writ, which now issues from the High Court of Justice, directed to any person detaining another, commanding him to produce the body of the person detained before the court, showing the day and the cause of his detention, to be dealt with as the law requires. The writ accordingly enables any person who is alleged to be unlawfully detained or imprisoned to be actually produced before the court, and the cause of his detention inquired into. Unless a legal justification for his detention is shown, the courts will then order his immediate release. The writ is granted ex debito justitiae, and may be issued not only during term, but also during vacation by any judge of the High Court. It will be issued on the application either of the prisoner himself, or of any person who satisfies the court or judge that there is prima facie ground for believing that the prisoner is unlawfully detained. The remedy is open not only to British subjects, but also to foreigners imprisoned within the realm. If the writ is disobeyed by the person to whom it is directed, he is liable to be attached for contempt of court. The Habeas Corpus Act of 1679, which applies only to persons detained on a criminal charge, contains provisions to meet various devices by which the common law right to the writ had been evaded, and to secure that the prisoner shall in suitable cases be admitted to bail and in any case be promptly tried, and imposes heavy penalties for the refusal of the writ and for disobedience to it. At various times in periods of political unrest, statutes have been passed enabling persons to be arrested on suspicion of treasonable practices and certain other offences, and detained without bail or trial. Measures of this kind do no doubt to a limited extent suspend temporarily the operation of the Acts of 1679, but these statutes, though they have been called Habeas Corpus Suspension Acts, have not in any sense suspended the general right to the writ of habeas corpus, nor have they legalised any arrest or imprisonment which would not have been otherwise lawful.